Welcome back to Winning Isn't Easy. Okay, do you have to provide your disability carrier with objective medical evidence of an illness to get your ERISA disability benefits? Now, you just may have thought that, hey, I'm disabled because of an illness or an injury, and I should get my benefits. Well, that's not always the case. There are no uniform disability insurance policies or plans in the United States, and many disability insurance carriers or plans have multiple versions of their disability plans or policies, and the terms can differ significantly from policy to policy or plan to plan. So let me tell you a little story. This is the case of Ziegler versus Sun Life Assurance of Canada. It's out of Missouri. Ms. Ziegler applied for her ERISA disability benefits after she was diagnosed with lupus and related autoimmune disorders following the birth of her child. Her doctors really assigned some very severe restrictions and limitations and supported her claim that she was unable to perform her own or any occupation. So she submitted her claims to Sun Life, and guess what? Her doctors disagreed with the restrictions and limitations assigned by her treating physicians. Of course, Sun Life denied the claim, and we end up in federal court. So what did the judge do? Well, the judge said, look, I want to examine the terms of the policy or the plan. What does it say about proof of claim? And there are proof of claim provisions in every policy or plan. And the plan required the following proof of claim. Quote unquote, the proof of claim has to consist of at least the following information: a description of the disability, the date the disability occurred, the cause of the disability. Proof of claim may include, but is not limited to, police accident reports, autopsy reports, laboratory tests, toxicology reports, hospital records, x-ray reports, narrative reports, or other diagnostic testing material as required. Proof of claim must include evidence demonstrating the disability, including but not limited to hospital records, physician records, x-rays, narrative reports, and other diagnostic testing materials as appropriate for the disabling medical condition. Now, in all that gobbledygook, did you ever hear the words objective medical evidence? No, but that was the basis of the denial. Sun Life's doctors disputed the diagnosis of lupus, citing the lack of a physical examination, findings, and reports consistent with the diagnosis and the restrictions and limitations assigned by Ziegler's treating physicians. So Ziegler appealed, submitted new medical records, which still didn't address the objections raised by Sun Life's doctors. And she didn't undergo a functional capacity evaluation or other testing to determine the basis of her restrictions and limitations. Now, another key provision in the policy or plan is what we call the discretionary clause. The plan gave Sun Life the discretion to determine Ziegler's entitlement to benefits, and the judge would use and will use that standard of review to uphold a denial. The judge noted that in some circumstances, it's reasonable for the plan administrator to interpret the plan to require objective evidence as proof, as part of the proof and documentation that the claimant is required to submit. Now, proof is an ambiguous term. While the plan clearly outlined the requirements for proof, the judge found that despite the denial of this claim based on the lack of objective evidence, Ziegler didn't prove that Sun Life had abused its discretion by relying on its physician's opinions. I think this is flawed reasoning. The plan did not require objective evidence, and Sun Life's rejection of the treating physician's opinions, based on the lack of objective evidence, I think was flat out wrong. But I also think that the bigger issue was Ziegler didn't provide the appropriate documentation of her diagnosis and adequate proof of disability. And it's incumbent upon you as the plan beneficiary or the policyholder to provide that very evidence. Now, I disagree with the judge's decision, but I understand the reasoning. What do you think? Let's take a break.
Have you been robbed of your peace of mind by your disability insurance carrier? You owe it to yourself to get a copy of Robbed of Your Peace of Mind, which provides you with everything you need to know about the long-term disability claims process. Request your free copy of the book at caveylaw.com today.